right, calling our next case, People versus Fredell. This is a 15-minute mini oral argument on the application. You both have 2 minutes of a free fire zone, which you may waive, and you may reserve time for rebuttal, but we ask that you do your best to keep track of that time, and you may begin when you're ready.
Good morning, Madam Chief Justice. May it please the court. Michael Frone on behalf of Mr. Fredell. I will waive the free fire zone. I will attempt to preserve a few minutes in rebuttal.
I'm sorry, 3?
3 minutes. Thank you. My client's convictions arise from a tragedy which my client regrets. He is going to serve his minimum term, regardless of how the court decides today's case. However, there is a difference between, no difference between gross negligence and recklessness in Michigan criminal law. Both terms have been used interchangeably in Michigan criminal law. Therefore, the convictions for involuntary manslaughter, premised on a gross negligence theory, and for recklessness driving causing death impose multiple punishments for the same offense. Appellee initially agreed with us before the Court of Appeals. Amicus for the prosecution in their brief concedes that the two elements are the same. The two offenses can't be distinguished. The Court of Appeals in its decision seems to have recognized that Michigan case law has blurred the distinction between the two, between gross negligence and recklessness, making the terms difficult to distinguish in their application. They never actually offered a definitional distinction between gross negligence and recklessness. Instead, they found that one is more serious than the other. One carries more culpability than the other. That's based on a dicta in People v. Fiesel. As the
so do we have to reverse Fiesel for you to win?
I'm sorry.
Do we have to reverse People v. Fiesel for you to win?
Absolutely not.
Just distinguish it.
Exactly. I mean, I read that comment in Fiesel, it's dicta, it's not a holding. There's absolutely no need to reverse Fiesel. There's actually no need to reverse any opinion that I found other than, of course, the Court of Appeals opinion in this case. As the amicus for the prosecution concedes, actually, when we look at Professor Lefebvre's treatise, he surveyed American law and made the opposite finding, that recklessness is the more culpable state of mind. Now,
let's take a step back here. So I believe that what you're arguing is that it's impossible to commit reckless driving causing death without committing involuntary manslaughter under gross negligence. So if that is true, why would the legislature enact a separate statute with the same 15-year penalty? Wouldn't involuntary manslaughter just cover that?
Well, my initial reaction to that is that they do that all the time. The legislature enacts laws all the time that aren't necessary. There probably was, at the time, a concern about driving fatalities. They enact a statute. There's no indication.
But usually the legislature, I mean, they don't just enact statutes that they already have statutes that cover. It's usually just to try to solve a problem or where they see,
sure,
you know, an inadequacy, right, where something isn't covered. It's not often, I can't think of an example where the legislature has a statute on the books that covers conduct that no one is saying this conduct isn't covered by the statute, and then they go and enact the exact, you know, something very similar to cover the same conduct,
right,
with the same penalty.
Also, this, in my mind, comes close to the discussion that Appellee makes at the bottom, page 14, top of page 15 of the brief, where they talk about voluntary manslaughter does arise out of the common law, reckless driving causing death, statutory offense intended to regulate traffic or make safer roads. It's possible the legislature, I'm trying to read something, there's no legislative intent expressed. I'm trying to read the minds of a group of people. I can't do that, but it's possible that that's how they saw it, that we're going to enact a statute to, for the purpose of regulating traffic or making the roads safer. But my point is that brings us back to, that's the social norms test that this court rejected or in People v. Smith. That's the old social norms test for double jeopardy. My understanding from this court, from People v. Miller, is we're supposed to look at the text of the statute. I understand involuntary manslaughter, there's no statute per se, but look at the text of the reckless driving statute and ask, did the legislature express an intent? And they didn't. And so that should be the end of it. My understanding is this court from several decades now has disfavored legislative history and these sorts of things. We're supposed to take a textualist approach, looking at the statute, the reckless driving statute, and it's not there. Because it's not there, because no legislative intent is expressed, then we turn to the analysis, the Blockberger test, which looks at the elements of the offenses. That's where we are in this case. The elements of the offenses are impossible to distinguish. They haven't been distinguished, and I think that's why the reckless driving conviction has to be vacated. Now, a prosecutor can still submit both charges to a jury. They're allowed to do that. It's just the case that at the end of the trial, if the defendant is found guilty on both, the court has to remedy the matter by vacating the one. They can still submit both. And there may be a pragmatic reason for submitting both. It's possible, the way the elements of the two offenses read, that a jury could view one as less culpable than the other. They could view reckless,
So what are we supposed to do with that? If let's say we agree with you.
Right.
And we agree that one of the sentences needs to be vacated. They both have a 15-year penalty.
Right.
Which one is the lesser?
I've stated reckless driving as the lesser. I think possibly that's based on the crime class. I'm not sure why, but I would look and see which is the lower crime class offense, and what I would ask for is a ruling that the two, there could be a narrow ruling that the two offenses violate double jeopardy. There could be a broader ruling, which might be helpful, that gross negligence and recklessness in the Michigan criminal law mean the same thing. And I've gone through, I've looked at many other, maybe a dozen other, maybe more offenses in Michigan criminal law that use the term recklessness. I didn't find any which use both gross negligence as one degree of the offense and recklessness as the other. You know, if we look at, for example, the vulnerable adult abuse statute, fourth degree, that uses the term recklessness. And it's interesting to compare the jury instruction 17.33 to the general jury instruction on gross negligence, and they read the same. Not literally the same, I shouldn't have phrased it that way, but vulnerable abuse statute defines recklessness as follows. Conduct that demonstrates a deliberate disregard of the likelihood of the natural tendency of the act or failure to act to cause physical harm. If we look at gross negligence, willfully disregarding the results to others that might follow from an act or failure to act. So a broader ruling from this court would be to simply hold that recklessness and gross negligence have the same meaning in Michigan criminal law. Why would that be helpful? Because the courts, I understand the trial court in this case wasn't asked, and we can talk about that. When they are looking at these two statutes, how is a trial court supposed to distinguish gross negligence and recklessness if asked, confronted with the double jeopardy issue? I think the easiest way to resolve this would be that they mean the same thing. And in fact, they do mean the same thing in a Michigan case law. They've been used interchangeably for many, many years.
So that gets to you're saying the trial court wasn't asked to confront this issue, and you said that there may be circumstances in which it might make sense, or you might want both to go to a jury, and that for a defendant to have adequately preserved the ability to now argue that here, what is like the minimally sufficient basis for them to have preserved that? And
well,
when? Like in your scenario that it might, they're not going to object to them both going to the jury because
right.
Maybe that makes sense. Is it only upon a finding of both, or the judge entering a judgment that on both?
Well, what would happen is after the jury returns its verdicts, if they find the defendant guilty of both, the defense or someone should move to vacate one of the offenses. And that, by the way, happens where, can't think of an example, but it does happen where you can have that a finding of guilt on multiple offenses, even though they violate double jeopardy. It could be cleaned up after the trial. That's not unusual.
Did that happen here?
No, it didn't, and in this case, in this particular case, I should have gone back to the trial court. That would be, when I say should have, that would have been preferable. I kind of explained in a footnote why I didn't. I don't know if that's a satisfactory explanation or not, but in this particular case, this is a bit different from, and I won't repeat, I know the court's heard the arguments regarding jurisdictional issues and how we're actually asking to have something set aside which the prosecutor wasn't entitled to. And I won't repeat those arguments. What I'll add to them by stating that, we are further down the road here. Our case is different from the previous case in that we have a Court of Appeals opinion. So when the amicus argues, well, at the time, really, my understanding, my reading of amicus's brief is that at the time of the trial, there was no case holding that there was a double jeopardy problem. That's true. Therefore, there can't be plain error. Okay, but we now have a Court of Appeals opinion, and at the time of trial, there was no opinion. There was no opinion at all. There was no guidance at all. I would argue that for that reason, the plain error doctrine doesn't apply. This court's reviewing a published Court of Appeals opinion, which isn't going to have that much impact on Mr. Fredell, but will impact others. And I would argue that. I would argue that Judge Farah, the trial judge, he did comment on, he did make a statement. I didn't make this argument in front of this court. I did make it in front of the Court of Appeals. Then I abandoned it because I didn't want to come across as, they dismiss it in a footnote 2, and I was afraid I'd come across as being trying to be too clever. But when you stop and think about it, the judge did make a finding. He said, quote, "There's no double jeopardy problem on these crimes." And you can find that again in the Court of Appeals footnote 2. That makes this, it's not, we don't have a record where, granted, that statement was not made pursuant to an objection. There was no real argument from defense counsel disagreeing with that statement. It wasn't, in that sense, a proper objection. But we do have that statement from the trial judge. And I think when a trial judge makes that statement, we have to assume there was some thought behind it. He was stating it for a reason. He did make a finding that there was no double jeopardy problem in this case. So I think that should be said in response to the plain error argument that's been made.
If we were to agree with you but find that because of the lack of preservation, your client doesn't benefit from it, is what we say about it dicta going forward?
I would be happy with that decision. It would be unfortunate for Mr. Fredell. He'd have one more felony on his record. I think you can tell from this briefing and some things that have been said that Mr. Fredell's been very passive. He's really, this is an individual, he's really has remorse for what he did, and frankly, I could have dismissed this appeal. If I'd asked him to, he probably would have. So I think we'd be fine if the court were to make that type of a ruling. And I think it would be helpful.
You're at the 2-minute mark, if you want to reserve time.
I will, thank you.
May it please this honorable court, Katie Jory on behalf of the people. This case boils down to whether this court believes willful and wanton disregard and gross negligence legally encompass the same behavior in the context of involuntary manslaughter and reckless driving causing death. In the Court of Appeals, the people conceded this point. The Court of Appeals held that the people were wrong and that gross negligence and recklessness, despite similarities, were separate and distinct legal concepts. Thus, under the abstract legal element test, double jeopardy was not violated. After reviewing the Court of Appeals opinion, the people were persuaded that its interpretation of the law and statute is more correct than the one originally proposed by the people and defendant, and now seek to defend a correctly decided published opinion. Still, this is a very close and difficult question to answer, especially since there is nothing to examine for the legislative intent of involuntary manslaughter. But regarding reckless driving causing death, one could assume it would have been pointless for the legislature to enact MCL 257.626 in 2010 if the same behavior was already prescribed by involuntary manslaughter. Unless a statute clearly evinces an intent to overrule the common law, it is presumed that the legislature intended to incorporate the common law into the enactment. There's no evidence that the legislature intended to overrule the common law by enacting reckless driving causing death in the statute. A grossly negligent person realizes the risk of their behavior, consciously decides to create that risk, and is excessively indifferent to the results. A person who drives recklessly causing death knowingly disregards the possible risks to the safety of people or property. These terms are not legally synonymous. The convictions do not violate multiple punishment prong of double jeopardy, and defendant's application should be denied.
Can I ask you, do you agree, do you agree that the fact that one of the crimes here at issue is a common law crime and the other is a statute, that there's no, that the Blockberger, comparing the elements of the crime is what's relevant, not, even though in Blockberger they said the statutory elements?
Yes, I do believe that defendant and I both agree that this is essentially interpretation case that can be analyzed under Blockberger, even though Blockberger was kind of set up to analyze two different statutes.
Common law elements. Yeah.
Yes.
Okay.
So, it seems to me the Court of Appeals compared the mens rea of gross negligence with that of recklessness. But is that the correct inquiry? Reckless driving causing death has a statutory mens rea calling for willful or wanton disregard for the safety of persons or property. And so it seems to me that the proper comparison should be between gross negligence and willful and wanton disregard. And we have case law that says that those two are essentially the same. So from my reading of the law and the statute, it seems to me the Court of Appeals botched this one. Where am I wrong?
So I believe that the case law the Court of Appeals relied on did support their conclusion. But also, I think that we have to go back to the fact that the statutory language is clear and unambiguous for reckless driving causing death. And as far as legislative intent goes, I would fall back to my argument before, was if this was already prescribed by involuntary manslaughter, then why would they have enacted this reckless driving causing death statute in 2010? So I don't think that the Court of Appeals botched it, as you put it, but I do understand that.
I agree with you, the statute's clear. It calls for a mens rea of willful or wanton disregard for the safety of persons or property. And I read the Court of Appeals opinion as comparing gross negligence with recklessness. And I don't think recklessness is the same as the statutory call for a mens rea of willful and wanton disregard for the safety of person or property.
So my understanding from the Court of Appeals argument is that they were comparing gross negligence and willful and wanton disregard, which was the definition of recklessness, and they were using recklessness as shorthand for willful and wanton disregard to people and property, so they did not, and I guess this is just my understanding, but when you're writing an opinion, it would seem to not flow very well if you consistently repeated the definition when the definition is, kind of clunky, and you have the nice word reckless or recklessness that you can use in its place.
Okay.
Are there further questions at this time?
So just to be clear, really this comes down to a difference between willing disregard and knowing disregard. And you think they're different?
I think that it comes down to essentially a willing indifference. That's what the case law has kind of always interpreted gross negligence as, is an excessive indifference. And I think that a lot of the case law has kind of expounded upon what gross negligence is, but that if we go back to the definition of gross negligence that this jury was read, which is in the jury instructions, which is set out from, I believe, People v. Orr, which dates all the way back to 1928. Knowledge of a situation requiring the exercise of ordinary care and diligence to avert injury to another, ability to avoid the resulting harm by ordinary care and diligence, and the use of the means at hand, and the omission to use such care and diligence to avert the threatened danger, when to the ordinary mind it must be apparent that the result is likely to prove disastrous to another. That's actually Orr, and the criminal jury instructions are just a little bit different, but not much. And I would say that in this case, the jury was instructed as to what the standard model jury instructions, and I know those are not binding, but my point is that the jury was instructed with the standard criminal jury instructions for gross negligence with that definition, and for reckless driving causing death with the definition of reckless being the willful and wanton disregard. And the jury found that the people proved beyond a reasonable doubt each of those things. And I think that, the fact that the jury didn't seem confused by it also is indicative of the fact that they are different. Are there any further questions?
I do have one more question for you. If we disagree with you and we conclude there was error, wouldn't it be reasonable to consider it plain error, especially since you initially thought it was plain enough to concede?
So in this circumstance, I think that plain error is the appropriate standard of review. And to get to Amicus's point, I don't think they conceded. I think that Mr. Baughman said that this was a very difficult, not clear, not obvious sort of scenario. And so in that way, it cannot be a plain error. It is not clear or obvious in this circumstance that gross negligence, that involuntary manslaughter under a gross negligence theory and reckless driving causing death violate the multiple punishment prong of due process.
So there needs to be the first case.
There does need to be the first case.
Where a defendant is out of luck for it, even though we find, if we were to agree with the defense position, there needs to be a first case where that defendant doesn't benefit, but those going forward would.
I think there does always need to be a first in these sorts of situations.
Okay.
Are there any further questions? Most of what I prepared, I believe that this court has already diligently reviewed in my brief, and so in the pursuit of brevity, if there are no further questions, I will just ask that this court deny defendant's application for leave to appeal and be seated.
Thank you.
Thank you.
Two brief points. First, the jury wasn't confused because the elements are the same. If the jury was going to find the defendant guilty on one, they'd find him guilty on the other. There was no reason for the jury to be confused. I don't think that really enlightens anything, respectfully. The other point, we do have a statute to look at, the reckless driving statute. When the legislature enacted it, they could have put in the statute that a conviction under this offense doesn't bar a conviction, the standard language they use, for any other offense arising from the same conduct. The court has that case, one or both of the two previous cases have that type of statute where the legislature puts that in the statute. They didn't put that in the statute. So we don't have an express legislative intent, so we go back to Miller, the Blockberger test. And finally, we're not asking the court to overrule involuntary manslaughter or abrogate it or anything of the kind. Again, jury could be given both of these offenses. There would be practical reasons why a prosecutor may want to do that. So we're not asking the court to do away with involuntary manslaughter or anything of that kind. That's all I have. Thank you.
Thank you. Thank you both. The case will be submitted.